Right, back live tonight here on In Focus, and thanks for staying on. Parliament's Legal Services has given the Basic Education Portfolio Committee the green light to adopt a report on the Basic Education Law Amendment Bill, otherwise known as the Bela Bill. This paves the way now for parents to enroll their children at grade R at a much younger age, but with some conditions. For more on this conversation, we are now joined by Bongiwe Mbinqo-Gigaba, Chairperson of the Basic Education Portfolio Committee. Chairperson, good to have you, and thank you very much for your time. You sought clarity on those two areas, one being the age in which parents can be able to enroll their kids at school, others saying they want to do that a little bit earlier. But the second question is whether or not, again, having SGBs approve the language policy, can this decision now only be taken to one person in the department to make a decision on whether or not this is approved? What did the legal service say about those two areas?
Good evening, Tabu, to yourself and the viewers at home. Like you are saying, we did receive a legal opinion that actually is giving us a go-ahead with the issues of Bela Bill. One, the issue that the committee sought opinion on, as you are correctly raising it, is the powers of the HOD, that must be the ones that approves the admissions and the language policies. As it was raised as a concern. But the legal opinion is in agreement that there is nothing that is wrong with that. Because remember, it's when the SGP, you are not taking the powers away from the SGP, but it's when the SGP would not want to for instance, admit a child at school. But if that parent is not satisfied, then we can go to an HOD, and the HOD of calling to the last person after having considered everything that would want to be considered. So yes, legal services is giving a go-ahead on that. Now the other issue that we are raising as to when the child would go, a technicality of whether you say 6 years, then you would add 6 months, and you would start to say starting from June, or you would start to say whether that child is turning 6 years or 7 years, rather in January or June. But we removed that, and then we said the status quo should be what it is now, that a child, when it's 5 years, a child can be in grade R. And a child, when he's 6 years, a child can be in grade 1. So I think that's what you were raising, and
yeah.
We were giving
so what are the conditions that are attached to that second clause that is around compulsory admission?
Admission of school children is compulsory. Remember, say what the department was proposing was that if, for instance, you would be a parent that is not taking your child to school, then you should face a jail sentence of approximately 12 months, actually 6 months or 12 months, but then we have amended it to 12 months. So that has been agreed to, that when this bill can be actually enacted to law, then you would that would be that there should not be no child that must be laundering in the streets, and parents are not being able to account for the whereabouts of that child.
So if my child is turning, 7 in February, after the school year has started, are you saying now the legal advice says it's okay for me to enroll them earlier before they turn that particular age?
No, you can't involve them earlier. You must involve them at the right age. Like I'm saying, the child should be 5 years when they enter into grade R. And the child should be 6 years when they enter into grade 1.
So if they are turning 6 years in the middle of the year?
Middle of the year should not be beyond June. Middle of the year should be before June.
So, in other words, when they start attending, they are not yet at that age, you are saying that they should not be admitted.
Admission should be at the right age. So if you just say that we are saying they should not be admitted, but a child should be at the age where we agree that this child is right for that age. That's what the department actually is recommending. And the right age, like I am telling you, a child should be 5 years to be in grade R, and a child should be 6 years to be in grade 1.
Yeah, because I'm reading here, it's saying that the clause 4 seeks to amend section 5 of the South African Schools Act 84 of 1996. It provides that despite the age at which the school attendance is compulsory, a parent may enroll a child at a school to start attending grade R at a younger age if they so wish and subject to a few conditions. So that's what I'm trying to understand.
Younger age would be like I'm saying, grade R would be age 5 requirement. So your child, if it's 4.5, then you can enroll that child.
Right.
To grade R.
Okay.
4.5.
Yes.
Yes.
All right. No, that's what I wanted to get clarity. Okay, fine. Let's move on then to the other issues. I see the Democratic Alliance celebrating a victory to say the Parliament has agreed that all submissions will be scrutinized and considered. So some 9,500 emails that were submitted are going to be properly analyzed. Talk to us about that process.
The legal advice, again, I'm sure you read the legal opinion. The legal opinion, as much as it's saying, fine, we are giving you a go-ahead, you can move with the development. But then there is an omission of, actually it's not even 9,500, it's about 6,400 and odd submissions. So these submissions were not included as to what is the guidance now, what the members of the public are saying. And there were reasons for that term. So it says you can go ahead, but the advice we are giving you, should this matter be taken to court, then this will be a problem. So you sit down as a committee when you get this legal advice. You look into it, and then you agree that, okay, we have done everything. But this, we are advised legally that this can be a problem. So you revise, you take a decision, and you make a U-turn, you say, no, it's fine then. Let us look into those submissions. So then we have agreed as the committee, no, it's fine then. Let us not proceed with the meeting, let us attend the meeting. But then let us get a team from Parliament that will look into those submissions. So that is actually what has happened.
So does that curtail your broad discretion on what it means to have meaningful public participation? Or you are still going to then, I don't know, go through 2,300, go to 3,000 and then determine, no, this is meaningful? At what point would you say this is a meaningful public participation?
No. The submissions, it's a separate process from the public participation, right? Submissions were submitted, it's submissions that were there before we even embarked on public participation. So those submissions, it's what you would have received, whether they came to Parliament by email, whether they came orally, whether they came by people who brought them manually. So in this instance, it's what was received through emails. Like I was saying, there was a reason for that. For instance, people who would open emails would see that, one, these emails are coming from one email address. It's centralized email, one. Two, the content of the email is the same, and then the only difference would be a person that has, the people that they would put different names at the bottom. So when you look and there's a person who received this email, you would see that, but I'm doing the same thing. So the committee is saying it's fine, even if that is the case in some of the submissions. Let us look into an email as it comes, irrespective of whether the email address is one, which is now it's centralized. But let us agree that because of there are different names at the bottom. So that's where we are. Now we are fine-tuning that issue of submissions.
Yeah. And how are we to tell that those submissions are going to be given expression, I suppose, in the final bill?
Of course, they are going to be given expression. In fact, one of the reasons we couldn't proceed, because that meeting we were supposed to have today was going to deal with amendments. So you can't continue because you need to look into what are these submissions saying. So of course, if the submissions and the content of them would deal with some of the clauses, it would mean that you would need to go and revisit those clauses. That's what it means. Yeah. You would look into the content, what clauses are they speaking on, and then if there is a difference in terms of the whole number then of submissions that they have come to the committee, then if it impacts on how the A-list should be rephrased, then you do that, and then you still continue then with your A-list.
And Chairperson, has the committee agreed on what clauses should be completely scrapped? I believe there was, for example, in one of our panel conversations, a debate we had with some of the stakeholders around the sale of alcohol on school premises, saying that thing should be completely scrapped. And I suppose there were other requirements, for example, around the disclosure of financial interests of school governing bodies. Is there an agreement on whether those clauses will be scrapped completely from the bill?
Yes, there is an agreement on alcohol and also on the disclosures. We did agree that we will scrap them off, those clauses.
And what was the reason?
The public wants us to scrap them off.
Okay, so there's a broad sense from the public that those need to be scrapped. And when do you see this bill being formalized?
I honestly cannot tell you that because after our process, which is now the committee process, we must still send it to Parliament. Parliament has got also its own lineup, and it has got its own. For instance, there are many things now that Parliament must process too, and after that, it must also be sent to the NCOP. The NCOP must also do sort of the same process that we are doing, and then only after that it can be sent to President for him to sign.
All right, Chairperson of the Portfolio Committee on Education, Bongiwe Mbinqo-Gigaba. Appreciate your time. Thanks you for joining us.